damage was.
Here.
He did not vandalize her house. He vandalized the other house.
I don't believe a word of that. Give me my pen back. If you tell the truth, you don't have to have a good memory.
This is Judy Justice. Tanya Labriola is suing her neighbor, Noel Chang, for vandalism caused by her 11-year-old son, William.
Court come to order. All rise.
Have a seat, please.
Judge, case 3151, Labriola versus Chang.
Thank you.
You're welcome.
You own a home,
Yes, ma'am.
and it is your allegation that I assume this young man, who is your son,
Yes, ma'am.
vandalized your home,
Correct.
which had been freshly painted
Correct.
because you added an addition, so it was just painted, and he vandalized it by throwing paint on it and some fencing or some
ma'am.
wall. And the defendant's mother says he wasn't the instigator, he did in fact do it, but she was going to clean it off, and she thought your estimate to fix it was too high. So, what's your first name?
William.
Stand up with your mother. You're 10?
11, ma'am.
Tall for 11.
Thank you.
Okay. So, on what date did you vandalize the plaintiff's house?
Not sure.
What month was it?
December.
Saturday or Sunday?
Pretty sure it was Sunday.
Do you remember what time?
No.
Morning, afternoon, night?
Morning, going transitioning into the afternoon.
What were you doing outside? Did your mother tell you to go outside?
Yes.
And who did you go outside with?
My friend.
Did you take your bikes or did you walk?
Bikes.
And you went over to where the plaintiff's house is, and there's also a construction site. So I want you to go over there and show me where you and your friend went. All right, now, point to the plaintiff's house. Okay, so you went to the house next door?
Yes.
Were they doing construction at the house next door?
What do you mean by that? Like, people there currently?
You threw paint on the plaintiff's house. Where did you get the paint from? Show me in that picture. That's what I thought. So you got the paint from somebody else's house.
Yes, ma'am.
Do you understand? He got the paint from somebody else's house and took the paint to the plaintiff's house.
Can I clarify?
Sure.
My understanding is he did not vandalize her house. He vandalized the other house.
Well, you don't know that at all, actually. You don't know that at all because you weren't there. You don't know that at all.
Based on the evidence and what my son said, that it is true, he vandalized one house and the other kid vandalized the other house.
Okay. Now, come over here. If you tell the truth, you don't have to have a good memory. Take the pen and show me where you walked and where you got the paint. You walk there, and then stop where you got the paint. You got the paint there. How many cans of paint were there?
4.
4. So there were 4-gallon cans of paint?
No.
How big?
Yeah, big, not very big.
4. So you each carried 2?
No, I took 1, he took 3.
And what was your intention when you took the 1?
Use it on this house.
Use it for what on the house?
I don't know.
What do you mean you don't know?
I wasn't really thinking.
When did you and your friend separate?
About right there.
And show me where you stayed and show me where your friend went. What is that with the pen? You stayed where?
Here. Went here.
And you let him go there all by himself?
Yes.
I don't believe a word of that. Give me my pen back. Give me my pen back.
Yes, ma'am.
Now you can go stand with your mother. You have an estimate to paint the house.
I do.
May I see it, please? And I'd like to see the photographs.
Absolutely. I have an estimate for the repainting as well as the north side of my house. The fence was splattered with paint as well. And then I had 6 boxes of flooring that were damaged. And
Let me just
I have
see.
all of that. And here is the damages.
And the estimate that you got was $3,800, and you said that the other people paid $1,900,
Correct.
which is half. Okay.
Correct. And then I received an invoice for the fence painting, which I didn't have initially, and as well as
That's
the
too
flooring.
bad. That's too bad. $1,900, which, as you said, is half the estimate. Now I want to see Okay. So now I have this question for you.
Yes, ma'am.
When you came home, your mother said to you, you have paint on your shoes, right?
Yes.
And she asked you what happened. How'd you get paint on your shoes? Tell me what you told her.
I told her that I went over to the house down the road.
You got it at the house down the road.
Yes.
You had to have told her more because she went with you to where the damage was to the house and you started cleaning it with your mother, correct?
Correct.
And where did you start to clean with your mother first? Because pay careful attention, because when the plaintiff came home, she found you and your mother cleaning the house in the back. Do you understand?
Yes, ma'am.
So now what I want you to do is show me when you and your mother first came to the property, where did you show her the damage was? Go over there. Show me where you told your mother the damage was.
Here and here.
Well, how did you know the damage was there? You said that you didn't go there. How did you know that there was any damage there? When you pulled up in your driveway and found the defendant's mother cleaning your house, where were they cleaning? Show me.
Okay, the mom was over here and her son was over here.
So the son was cleaning the house that he allegedly had nothing to do with vandalizing.
And later today,
You mean instantly you had a fight with him in the morning, and then you were going to pursue your dream of motorcycle riding that day. And so you got on the bike and you wrecked it, and then was terribly injured, which you were, because that's what happens when you ride something with just the air around you.
Tanya Labriola claims her neighbor, Noel Chang, owes for property damage after her 11-year-old son, William, vandalized her house.
Now, you said that you stayed right in the back of that first house, and your friend went all the way up. Don't raise your hand. And your friend went all the way around the house with the 3 cans of paint that he was carrying. You only had 1. So how did you know that there was any damage to the plaintiff's house?
Because there wasn't any trees here, and you could just blatantly see them doing the paint over here.
It's not a flat house, it's a big house. Madam, walk over to the house and show me where the paint was on your house.
Can I show you a more accurate picture of the property?
No,
It's
no,
very
no, no, no,
unclear
no,
from
no,
this
no, no, no.
picture.
Put it down. Show me where the damage was to your house. In the back end.
It
Now,
was in all 3 sides, yes, ma'am.
all 3 sides.
Just not the front. So, yes,
And
ma'am.
you said that you didn't move from the back of the first house when your friend went all the way around the house. So my question now to you is, when you pulled up in your driveway and found the defendant's mother and this young man cleaning your house, where were they cleaning? Show me.
Okay, the mom was over here and her son was over here.
So the son was cleaning the house that he allegedly had nothing to do with vandalizing. Is that right?
Yes, ma'am.
Yeah, okay. Step back. You two. Anything else you want to tell me?
No, ma'am.
You know, I sort of know that this is the last time, at least I believe that this is the last time you're going to be in court like this. I sort of have that here because I think that this was an unpleasant experience both for you and your mother.
Yes, ma'am.
And when you get older, you realize that you don't want to repeat unpleasant situations because you get embarrassed. Your mother is embarrassed. I mean, your mother had other things to do rather than putting on plastic gloves and going scrubbing off latex paint on somebody else's house that day. So if you do the wrong thing happens. Now, if you do the right thing in life, it's not a guarantee that everything will go well for you. But I'm going to tell you, it's a damn good start. So if you try to do what is being a good citizen, what's being a good person, what's being a good neighbor. Do you live in a house?
Yes.
Does your mom own that house?
Yes, but I think she's still paying her mortgage.
Well, that she owns it if she's still paying a mortgage, but that's observant. So she owns her own house.
Yes.
How do you think she would feel if somebody came and threw paint on her house?
Upset.
Right. Because she's paying a mortgage. She wants it to look nice. She wants you to have a nice place to live. So you seem like a nice young man. And you have to realize that there are repercussions when you do the wrong thing. This lady had a house. She built an extension. She repainted the house. And somebody comes along and for sport vandalizes it with their friend. Because this was what we call a joint venture with your friend. Then you had to get your mother involved. This was on a weekend?
Yes.
So on a day when she does the working, she would ordinarily clean her own house. So instead, she had to get all dressed and ready and go and scrub a stranger's house. Not fair, right? Mm-hmm. Good. Judgment for the plaintiff in the amount of $1,900. We're finished. Thank you very much.
This court is adjourned.
Devastated because I'm a teacher, a single mom of 2, and I've been working for years to save. I work 2 jobs, so it's heartbreaking.
Ultimately, I'm the one who is going to be responsible for paying the bill.
No, I think they were just 12 or 11, whatever age they were, and just wanted to do what they wanted to do.
I hope this will put me on the path to do the right thing, and hopefully I really, really will try my best to not make this kind of mistake again.
That actions have consequences.
Ready to put it behind me.
Oh, how you love the youth and to set them on the right path. That was a very well-spoken, seemed confident, smart 11-year-old.
Yeah.
And I think you scared it into him to make the right choices. And this seemed like a one-off type situation for him. It didn't seem like this was a trait that he carries on daily, in his regular life. And you never know, this experience for him might just be the thing that keeps him from ever doing anything like this again. It might be the little voice over peer pressure, over, instigation that could save him from making another mistake in his young years.
I used to say that in family court all the time, that I thought it was unwise to allow young people like this, or a little bit older, who committed these acts of vandalism, knocked over somebody's vegetable cart, took rocks and threw it and broke a window. And they would go into the probation department and they would say, don't do that again, you don't want to have to come in here with your mother again. And they let them go home. And I said, it's a tremendous mistake, because if the first time you're brought into court, it's an unpleasant experience. People usually do not want to replicate an unpleasant experience. But if there's no consequence to doing these little petty things...
Then there's no contrary voice when you're about to do it.
There's no consequence, then that escalates. Because there has to be a consequence. As a parent, if you tell your child to be in at 9 o'clock and they come in at 11, and there's no consequence, then they're going to come in at 12. And if there's no consequence, then they're going to come in next Thursday. And you're going to deserve it. Yeah. Because there has to be consequential behavior. Anyway, I'm getting off my soapbox.
Case 3143, Child versus Hudson. All parties, please come forward.
Taylor Child is suing her former friend, Crystal Huddleston, for the cost of a motorcycle and riding boots.
I know very little about motorcycles. I know that the couple of times I've been on them, I didn't like it. Just seems to me that when you're surrounded with 3,000-pound cars, you want more around you than fresh air. So maybe I'll get somewhat of an education doing this case. I doubt it. You weren't in an accident with another bike. You wrapped the bike around a tree.
Yes.
And of course, that had to be somebody else's fault. Not the fault of the rider who was learning how to ride, but it had to be somebody else's fault who let you use the bike to learn how to ride.
Taylor Child is accusing her former friend, Crystal Huddleston, of owing for the cost of a motorcycle after crashing it into a tree. Crystal is countersuing Taylor for medical bills.
Miss Child, you like motorcycles.
Correct.
And you've been riding them a long time.
Yes.
And you purchased a motorcycle from someone used, and you paid $3,500 for it.
Yes.
Who's Scott?
Right here, ma'am.
That would be him. You and Scott work on the motorcycles together.
Yes.
And you brought the motorcycle back to your place, and you did some work on the chain and a lube job and who knows what else. But then when you tested it out, Scott thought, according to you, it needed a little more work, and he was going to take it back to his house to do a little more work on it. So far, correct?
Correct.
So Scott took this motorcycle back to his house. Now, this young lady doesn't ride motorcycles, but she rides as a passenger on motorcycles, but she wanted to learn about it, and she, too, was a friend of Scott's.
Correct.
So she was at Scott's house while he was futzing around with this motorcycle, and she decided she wanted to ride it and wanted Scott to help her learn to ride a motorcycle. Is not an answer. Is that correct?
No.
Tell me where I'm wrong.
The morning of September 29th, Taylor had my riding equipment in her car, and she and I had an agreement that I was going to learn with Scott on the bike. The night previous, we had a group chat.
And at some point, you had to have asked her if you could ride the bike. You know, certain things are common sense, certain things aren't common sense. Don't think about your ultimate counterclaim here, because that's not going to be good for you anyway, in all probability. You understand that?
Yes.
First, we have to take responsibility for our own actions. But at some point, you asked her if you could ride her bike.
Yes.
Okay. And at that point, you knew the bike was at Scott's house.
Yes.
And when Scott gave you the bike to ride, you rode it alone.
Yes.
Had you ever ridden a bike alone before?
Yes.
How many times?
5.
Whose bike?
Ryan's bike.
And Ryan is your?
Boyfriend.
Okay. When Ryan let you ride his bike 5 times, were you good at it?
I would like to think so.
Well, then what did you want to ride her used bike for? And learn how to ride?
I wanted to get more practice before I bought my own bike.
Okay, so you wanted to get more practice. Why didn't you ask your boyfriend if you could ride his bike?
Ryan and I were in a fight that morning.
So you mean instantly you had a fight with him in the morning, and then you were going to pursue your dream of motorcycle riding that day. Am I understanding you?
Yes.
Yeah, okay, good. So this is what happened. So you got on the bike and you wrecked it.
Yes.
And she's suing for the wrecked bike.
Correct.
And you're counterclaiming because you said, I didn't know that it didn't have a lube job, and I was terribly injured, which you were, hospitalized, right?
Yes.
Because that's what happens when you ride something with just the air around you. You weren't in an accident with another bike or a car. You wrapped the bike around a tree.
Yes.
And of course, that had to be somebody else's fault, not the fault of the rider who was learning how to ride, but it had to be somebody else's fault who let you use the bike to learn how to ride.
No, I take full responsibility for crashing this bike.
You take full responsibility. So why don't you pay her for the bike instead of counter-suing her for $10,000?
The bike was unregistered, uninsured, and Taylor and I have an agreement, or had an agreement, that I would pay her in full by March 29th.
Pay her in full for what?
For the bike.
And
the boots that she gave me.
So you had an agreement with her after this incident. By the way, what was the date of the incident?
September 29th.
Okay, so you had an agreement after you destroyed the bike and after you recovered from your injuries, you had an agreement with her that you were going to pay her for the bike by March 29th.
Yes.
Why didn't you pay her?
I have been paying the medical bills off.
Okay, well, that's fair. So in anticipation of your not paying her back, she's suing you now, and you decided to counterclaim.
Yes.
That makes my life so much easier. Good. Did she agree to pay you back for the bike?
Yes.
She's telling you this, in legalese, we call this an anticipatory breach. She's telling you now on March 19th that she's not going to pay you on March 29th. So 10 days from now, she's not going to pay you because she's been paying off the medical bills. That's why we're here.
Correct.
Judgment for the plaintiff in the amount of $3,500. Your counterclaim's dismissed. We're done here. Thank you very much.
This court is adjourned.
What happened is Taylor blatantly lied and said that I could ride her bike, and That's it. It's cut and clean. I crashed. I take responsibility for it, and that's it.
I didn't get full permission. It was discussed prior to the case, well, prior to the incident, that I would teach her, and they already had access to my bike.
I was on gravel. I lost control of the bike. I popped a wheelie, and then I popped another wheelie.
I received a call from Scott, my witness.
The clutch gave out, and I couldn't stop the bike, so I made a decision to not go into my car and go into a tree.
He said, hey, get here quick. Crystal's in an ambulance. She wrapped your bike around a tree.
Taylor and I are not friends.
We're not friends.
I don't like snakes. I'm sorry.
Rarely do we get one that easy. I mean, it was clear she rode the bike, she wrapped the trees, she damaged it.
She made an agreement to pay for it?
Made an agreement to pay for it, and although she didn't reach exactly, the 10 days from now in which she would have breached it, I think plaintiff was entitled to it. And you assume the risk when you do dangerous adult activities, such as riding a motorcycle, and just like you said, you can't shift the blame after the fact to anyone else out there. That's your own fault, and anything that comes to you, deserves to come to you.
That's it. Well, you need all kinds of IQs.
In a dramatic episode of Judy Justice, the courtroom buzzed with disbelief as a young man walked in, claiming he deserved compensation after what he described as a traumatic motorcycle accident. But as the story unfolded, it quickly became clear that this was no ordinary case, according to his testimony. He had been riding his powerful sport bike late at night on a quiet suburban road when he suddenly lost control and slammed directly into a tree, leaving the motorcycle completely mangled and himself lucky to walk away with minor injuries. However, instead of accepting responsibility, he filed a lawsuit against the property owner whose tree he hit, arguing that the tree was too close to the road and posed a danger to drivers, insisting that poor visibility and lack of warning signs made the accident unavoidable. But the defendant, an older homeowner, calmly explained that the tree had stood in the exact same spot for over 20 years, well within his property line, and had never caused a single incident before, making the claim sound increasingly absurd as evidence was presented. Things took a sharper turn when dashcam footage from a nearby car revealed that the rider had been speeding excessively, swerving between lanes moments before the crash, clearly losing control due to reckless driving rather than any external hazard. And when questioned, he struggled to justify his behavior, shifting blame repeatedly from the road conditions to the lighting, to the unexpected presence of the tree, until the judge, with her signature sharp wit, began dismantling his argument piece by piece, pointing out that roads are not cleared of stationary objects simply because someone might drive irresponsibly, and emphasizing that personal accountability cannot be ignored just because the outcome was unfortunate. The tension in the room rose as she pressed him on basic logic, asking whether he expected every roadside object to be removed for his convenience, and when he attempted to argue that they, homeowner, should have installed barriers or warning signs, she firmly responded that it is not a citizen's duty to protect reckless drivers from their own actions, drawing a clear line between legitimate negligence and blatant irresponsibility. By the time closing statements arrived, the narrative had completely flipped from a supposed victim seeking justice to a cautionary tale of entitlement gone wrong, and, in her final ruling, she dismissed the case outright, stating that the accident was solely the result of the rider's own negligence, adding a pointed remark that lawsuits are not a tool to escape the consequences of poor decisions, leaving the plaintiff visibly stunned while the defendant walked away vindicated, and the audience with a powerful reminder that sometimes the harshest